Hello, everyone, and welcome to a workers' compensation presumption regarding COVID-19, presented by Pat Moody with Barsamian and Moody. My name is Angelina. I will be moderating and looking at the questions. We're going to do a couple of administrative things before I hand this over to Patrick to continue his presentation. We have a simultaneous translation with this webinar. So we ask that you please click on the interpretation button at the bottom of the webinar screen. And you can select the language. Again, if it's English, you can select English. Again, this is more for people in Spanish. También estamos interpretando este webinario. Si necesita su asistencia o prefiere escucharlo en español, oprima la sección que dice español o Spanish y luego ponga mute original audio, si es que tiene esa opción disponible. Once you've selected your language, congratulations. You should be able to hear the presentation in the language you selected. If you are having trouble, please write a message in the chat function and we'll provide assistance. Otra vez, oprima el botón que dice interpretación en la parte de abajo del webinario. Estas son las instrucciones en español. Si escoge español, entonces va a poner Mute Original Audio. Haga clic en Mute Original Audio para escuchar. Felicidades, debería de podernos escuchar en el idioma que seleccionó. Si tiene algún problema, mande un mensaje usando la función de chat y se lo proporcionaremos ayuda. Gracias. If you can't hear the webinar, please make sure you adjust your audio. If you called in using a phone, adjust your audio accordingly on your phone as well. If you would like to ask a question of the presenter, you can type it in the chat function. We will be able to help you there. I'm keeping track of all of the questions. And then we do have a disclaimer available. I'll give you a brief moment to just kind of read through the disclaimer. Alrighty, and with that, I present Pat Moody with Barsamian and Moody. He has been doing employment law for the past 20 years, and it's a pleasure to have him here with us today. Thank you, Pat.
Thank you. Good afternoon, everybody. The one thing I would add to the disclaimer that isn't in here is that I am, in fact, not a workers' comp attorney. So I'm not a specialist in workers' comp. If you have super technical questions about workers' comp, I'm just going to have to tell you that I don't know the answers to some of those things. But I do know about this executive order and the presumption that's created, so I can talk about that. But if you have super technical workers' comp questions, I'm going to have to defer those to somebody else. But feel free to ask your questions. If I know the answer, I'll answer it. If I don't know the answer, I'll tell you I don't know the answer. But we'll be able to go through this and hopefully get a lot of your questions answered. We did get some questions yesterday from somebody, so we have some of those all ready to go. But the folks at AgSafe will be monitoring that section to see if you've got questions. They'll ask me questions, and I'll answer those either as we go along, or we'll save some time at the end. But we'll get your questions answered to the best we can. So what we're going to talk about today is the issuance of Governor Newsom's executive order. We're just going to talk about what it is a little bit. We're going to talk about the applicability of the presumption that it creates, and how an employer is supposedly to go about rebutting that presumption. We'll talk a little bit about how it affects disability payments, the temporary TDI payments. And then we'll talk a little bit about what this kind of all means and where is it going and what's this going to do. And then, like I said, we'll leave some time. I'll answer questions at the end as well if they don't get answered along the way. So feel free to ask questions. So first, the issuance of the executive order. It's Executive Order N62-20. You can find this order on either, there's a number of ways. It's at ca.gov COVID-19. It's if you Google, California Governor Executive Orders, there's a link to on the last page of this, there's a link to it. And so there's lots of ways to get to the actual full version of this. I believe that I recently sent a copy of it out to AgSafe, and I believe that AgSafe sent that on to their members. So it's pretty easy to get a copy of the exact wording of this. But the big thing here is that what this executive order does is creates a rebuttable presumption that any worker who contracts COVID-19, essential workers did so in the course and scope of their employment. So there's this presumption that they have got it at work and are therefore going to be entitled to comp benefits. It applies not only to essential workers, but all other workers who reported to work outside of their homes at their employer's discretion. So we know that means a couple of things. One is that this is not going to apply to workers that you might have who have been teleworking or working from home. If you've got office employees or whatnot who have been working at home and they get coronavirus COVID-19, this presumption is not going to apply to them. And so there's also this thing about showing up at work at the employer's discretion. So if for some reason an employee just happens to show up at work and gets this, but they were not told to come into work, it looks like this would not cover that. But otherwise, if it's an employee who's showing up to work, for a regular, work schedule, and they're essential workers, and I'm assuming that all of you are in ag, and so therefore, all of your employees are under that umbrella of essential workers. If they show up to work and they get COVID-19, there is this presumption that they got it at work, and they do not have to prove it. It's presumed so, and you have to prove that they didn't. Couple of time frame barriers to keep in mind here, or sort of benchmarks here. This covers claims retroactive back to March 19. So it goes back to the declaration of the emergency and the shelter-in-place order that Governor Newsom put out on March 19th. And it's currently scheduled to remain in place until July 5. So it's a short time window that this is going to cover, unless, of course, they extend it. We don't know if they will extend it, but they currently have it scheduled to sort of self-end on July 5th of this year. So it covers a fairly narrow time frame, but it is retroactive back to March 19. So it's going to go backwards in time. So let's talk a little bit about the applicability of the presumption. So for the presumption to apply, all of these following 4 factors have to come into play. They all have to be met. First, there must actually be a positive test for COVID-19. So this is not going to apply if somebody comes to you and says, "Hey, I got COVID-19. I know I've got it. I've got all the symptoms. I'm sick," whatever it might be. None of that is going to meet this requirement. They must actually go get tested and test positive. So there has to be an actual medical test that tests positive for COVID-19. It can't be just their word for it. They have to have that test. Then the test has to be within 14 days after they last performed work at your work site. So if they're working from home again, this doesn't apply to them, but they have to have showed up at work, for a regular, work that you directed them to show up for. And that must have been after March 19 of 2020. So if it happened prior to March 19, the presumption is not going to apply. So positive test, and it must be, the day of work must be after March 19. Continuing on, it must be made by the positive diagnosis must be made by a physician or surgeons who's licensed by the state. So this cannot be something where the chiropractor says that they're positive for COVID-19. It has to be diagnosed by a licensed medical doctor in the state of California. They can't go to a clinic in Mexico and get a test that says that they're positive. They can't go to Arizona and get a test that says they're positive. It has to be a positive test and a positive diagnosis made by a physician or surgeon licensed by the state of California. And then finally, it has to be confirmed by further testing within 30 days of the original date of the diagnosis. So there's going to have to be multiple tests showing that they are in fact positive for COVID-19. If they do that, they are presumed then to have contracted the COVID-19 at your workplace, and they are deemed to be covered for workers' comp. Now, there is this idea that the presumption of obtaining the virus at work is rebuttable. So you can in fact rebut it. Keep in mind though a couple of things here. One is that the workers' comp statutes in general say here they're to be liberally construed by the courts with the purpose of extending their benefits for the protection of persons injured in the course of their employment. So as a general rule, the idea behind workers' comp is that it is to be broadly and liberally construed so that if it's possible that it's covered, they want it to be covered by workers' comp. That's the goal of workers' comp, is that it's presumed, we want it to be covered according to the state. And so they've created this presumption that, even goes further than that. The executive order put out that the employer only has 30 days to reject and rebut the claim. So 30 days, it's not the normal 90 days. I know you're used to when you get a workers' comp claim, you have 90 days to investigate and rebut the claim or accept it or deem it accepted by not rebutting it. But this cuts that down in a third to 30 days. You've only got 30 days. So you're going to have to jump on these things really quickly and see what you can do to try and rebut it to the extent you can. And then any evidence used to rebut the claim must be discovered within 30 days from the date of the claim being filed. So if you find something out, 45 days later, it's too late. You got to find it within the first 30 days and reject and rebut the claim within 30 days, a very, very short time frame. So you're going to have to move really quickly on this. Now, when Governor Newsom had his news conference where he announced the passage of this executive order, or his issuing this executive order, what he said is that there would be quote unquote strict criteria for rebutting this. Now, he didn't emphasize or he didn't elaborate on what that might be. He did say that the state was going to be putting out some clarification on this, but they have not done so yet. It's been almost 10 days now, and they still have not put out anything clarifying how you're supposed to go about rebutting this. What kind of proof can you have to rebut this? What's going to be acceptable? They haven't done anything to help us here in terms of understanding what this entails. I looked, just a couple of hours ago this morning to see what might be out there yet, and as of yet, there's nothing. They did say that there's supposed to be something coming, but we haven't seen it yet. So no matter what, because of the liberal construction of the sort of the course and scope of employment factor and in general in workers' comp, rebutting one of these claims is going to be very difficult. I'm not sure what you're going to find that might rebut this. So it seems to me that if somebody comes and says they've got COVID-19, and you have to give them their DWC-1 form, and you're going to want to start asking, does anybody in your house have it? Have you been anywhere where you came into contact with somebody that has it? Have you been to a hospital? Have you traveled to out of the area? You're going to have to start looking for ways to try and figure out if there's somewhere else they could have got it, because the burden of proof is going to be on you to show that they contracted this somewhere else. I think it's going to be very difficult to do so, but at least you do have the chance. So if you come up with evidence to rebut it, we'll be able to try and do so. The big thing you want to try and do, of course, is to avoid it as much as possible. Make sure you're following the Cal OSHA guidelines and the guidance they put out. And they do have specific guidance that they put out for agriculture. CCD or CDC has put out guidance, and also with some applicability to agriculture. Make sure you're following all of that stuff, so you can at least try and argue that we followed everything that we were told to do, in terms of social distancing to the extent that you can, in terms of cleaning things and disinfecting things, and everything that those guidance and guidelines talk about. You want to be able to argue that you did all of that stuff. What else can you do? I'm not sure. We have to operate, and there's certainly going to be certain operations where you can social distance, and there's going to be certain operations where you can't social distance. And so you're going to have to do the best you can, but the best thing we can do is try and make sure that nobody gets it, so we don't have to deal with this whole presumption. But I have clients that have had this show up, and there's certainly examples in agriculture where employers have had positive test results. I've had a number of them call me that have had positive results, and so we're not going to be able to avoid it completely, I don't think, but do the very best you can to try and not have somebody get it, so you don't have to try and deal with this rebuttable presumption. The benefits that are going to be available to somebody who gets COVID-19 and is presumed to be work-related are the full scale of benefits that you would get under workers' comp. Hospitalization, surgical treatment, medical treatment, disability indemnity, death benefits. If someone is to die, they get the full scope of comp benefits. One thing that they did say in here, though, is that prior to getting temporary disability payments under the comp system, that the employee who tests positive for COVID-19 must exhaust all paid sick leave. So if they've got their 3 days or 24 hours in California of regular paid sick leave, they've got either the 80 hours under the state supplemental paid sick leave if you're over 500 employees, or the federal paid sick leave if you're under 500 employees, 80 hours of that. So all of that has to be exhausted prior to them getting temporary disability payments under the comp system. So they're going to have to exhaust all of that before they do so. To get the temporary disability payments, it's sort of it's pretty similar, but they have a cutoff date of May 6th, which is when the executive order came out. So if somebody tests positive after May 6th, then they have to be certified for temporary disability within 15 days after the initial diagnosis, and certified every 15 days thereafter for the first 45 days. Or if they were positive prior to May 6th, they have to obtain certification within 15 days of the order, which is May 21st. So they have to have gotten certified by then, and it had to show that they were temporarily disabled and unable to work. And then they have to be recertified every 15 days for the first 45 days. So it just depends on whether it's before or after May 6th. It varies a little bit there, but they do have a very short time frame, 15 days, in which they have to get certified as temporarily disabled due to this. And then they have to have follow-up recertifications every 15 days under either before May 6th or after May 6th. Certification, again, has to be by a California licensed physician. You know, again, it can't be the chiropractor. It can't be, other, healthcare providers that might otherwise certify comp injuries or disabilities. It has to be a physician and surgeon licensed by the state of California. Again, not out of state, not out of country, must be licensed by California. The physician can be designated in the MPN or your healthcare organization. It can be a pre-designated doctor in the employee's group health, say pre-designated their doctor. But whatever it is, it has to be somebody who is in fact licensed by the state of California as a physician and surgeon. So that's the MD license in California. So they have to have that. It can't just be anybody, or again, like I talked about earlier, it can't be somebody who just feels like they're sick and they feel like they've got this and they've got all the symptoms. They have to go get an actual test and be tested and confirmed positive by a licensed doctor. And then the temporary disability certification must also be done by a licensed medical doctor from the state of California. Applicability, this applies to all comp carriers in California. It applies to all self-insured employers. Previously, SCIF had said that they were going to presume that employees had acquired COVID-19 at work if they were an essential employee. This executive order just puts that on everybody above and beyond SCIF. So if you're insured by somebody other than SCIF, then this applies to them too. And if you are self-insured, this presumption arises as well, even if you're self-insured for comp. What does this mean? So what does this mean for employers? First, I think it means you're going to see lots of claims. Particularly, I think, as the ability to do more tests and more testing comes around, we're getting, more and more people are able to go get tested. I'm in Fresno, and so I was just looking yesterday at the numbers, and we've tested about 12,000 people so far in Fresno, and that number is increasing, more rapidly as time moves forward. And so I think as more testing gets done, you're going to see more positive results. Just in reading a lot about this, it seems like a lot of people have been exposed to this. A lot of people have it that don't have very severe symptoms. And so there's a lot of people that get this that might not just feel good for a couple of days. Not everybody ends up in the hospital. Not everybody dies. Some people get it and they really don't feel much. I've talked to people who've had it in other parts of the country, people that I've known that have had it, and some, ended up in the hospital, and some said, yeah, it just didn't feel very good for a couple of days. And so it's really, it's kind of hard to tell, but the general consensus is that a lot of people have this. And so the more testing that they do, the likelihood of positive results will increase as more people get tested. So that's something I think we're going to see lots of claims. When you've got only 30 days to investigate and rebut the claim, and if you don't rebut it within 30 days, it's presumed covered. You don't have much time to try and figure this out. So you're going to have to start doing whatever you can do to try and rebut this as soon as you can. And again, I think it's going to be, asking them about, people in their household who have it, and have they been to the hospital to visit somebody for some reason, or did they end up in the hospital for some reason? Did they travel out of the area? Those kinds of things. I think that's about all you're going to be able to do. I can't think of great ways to figure out how somebody got this somewhere else. I think it's great that they call this a rebuttable presumption so that at least we can try. But I honestly, I'm having trouble thinking about ways that you're going to try and rebut this kind of stuff. I think it's going to be very, very difficult. The cost of this is going to be enormous. The Workers' Comp Insurance Rating Board said that even just counting only essential workers, not other workers, the cost is going to be somewhere between $2 billion and $33 billion. Median discussion was somewhere in the $11 to $12 billion range. And now the state is opening up more sectors of the economy. You know, so different counties are opening up different things at a different rate. But so, for example, here in Fresno, we were able to open, like clothing stores are allowed to open now, and some other retail stores are allowed to open. And so as those people going to work at those places are all going to be covered by this presumption. And so the cost, you know, the estimate of, you know, roughly a median cost of $11 to $12 billion is certainly going to go higher. And so that's all money that is going to get passed on to employers via rate increases. You know, your X-mod's going to go up and you're going to get rate increases. The other thing that people are thinking about is, you know, how many more carriers are going to pack up and leave the state if they've got to cover this, and then, you know, try and recover it from their policyholders. You know, it's getting harder and harder to find carriers to write workers' comp in California, and I think this is just going to push that a little harder. And you know, SCIF is going to get a lot more business because I think some carriers may decide that they're going to leave the state. There is a little hope out there. 8 other states have adopted a presumption like this, other than California. And so there's 8 other states. None of them have gone quite as far as California did in their presumption, but there are 8 other states that did this. Illinois, a court in Illinois has actually blocked that presumption, saying that it's not proper to have that kind of a presumption. And so, is it possible that some group in California will file a lawsuit and try and get this blocked? It's possible. I'm not sure, you know, who's going to step up and do that. It's such a short time frame too. How is that going to play into it? Because it, you know, it only covers claims going forward to the 5th of July. And so it's possible we may get some sort of emergency restraining order or something like that, but I haven't heard yet of anybody that's stepping up to do that. And it would seem to me that it's going to have to be, you know, some of the large carriers would have to do that. Any of the large, you know, employer advocacy groups are going to have to step up if somebody wants to do that and see if they can get some sort of relief in court through litigation. I don't know how that's going to play out. We'll see, but at least we know that at least in Illinois, it was in fact successful, and they were able to get their workers' comp presumption. They're blocked by the court. So we'll see what happens there. Okay, so that's a quickie. I've gone through that. All the material I had. I did get, like I said, I got some questions yesterday, and I want to go through those. I'll answer those. I know we've got a couple people that have written in questions in the question and answer section, and we'll look at those as well. And so let me go first with the questions that we got yesterday. What it talks about here is that the order appears to indicate that COVID-19 is presumed to be industrial if they're positive and it's confirmed by tests within 30 days. In other words, the order suggests the employee does not have to say it is work-related. And that is absolutely true. I don't think that an employee has to say, hey, I got COVID-19 and I got it here at work. I think if somebody comes and says that they're positive, I think you need to give them a claim form. And then you have to start your investigation and see if you can rebut it. So this question, another question I asked is, if the workers' comp insurance carrier instructs the employer to only report a claim if the employee has a positive test or diagnosis, and the employee indicates that they acquired the illness at work, and they said, do those instructions appear to be inconsistent with the order? So if your carrier is telling you that they have to test positive and they have to say that it's acquired at work, is that inconsistent with the executive order? And my response to that is absolutely, that seems to be inconsistent with the order. You know, the idea behind the presumption that they obtained, you know, COVID-19 or acquired COVID-19 at work is that they don't have to tell you they got it at work. If they say they got it and they were at work, it's presumed that they got it at work. So if they you know, were having to tell you, oh yeah, I think I got it at work, that does away with the presumption. So I don't think they have to tell you that they got it at work. I think they just need to tell you that they're positive, and I think that starts the presumption that they got it at work. The next one, if there's no discussion about providing a claim form, does this mean that the carrier does not want us to give them claim forms unless they explicitly say they think they contracted the illness at work, or should we give them a claim form and say something like, were you exposed to the virus and do you think it's work related and wish to file a claim? My response to that is, I think that if somebody comes and tells you that they are positive, that I think you have to give them the claim form. I don't think they have to say that they got it at work. I don't think that they have to say, yes, I want to file a claim form. I think you have to give them the claim form. We have all those issues that come up if you don't provide somebody with the claim form in a timely basis. And so we want to make sure we're not falling into that problem as well. So I think because it's presumed that they got it at work, that you're probably going to have to give them the claim form and then try and rebut it when you can. Is there someone at your house that's positive? Have you been around somebody who's positive? Have you been to a hospital lately? Have you traveled out of the area lately? Those kinds of things, I think, is where you're going to have to start, and then just see what you can do to try and come up with something that rebuts that they got it at work. If we are aware that other workers are positive that have new cases we suspect are due to exposure to existing employees that are positive, what do we do? I said, again, if you know they're positive, you need to give them a claim form. If you think they're positive, but they don't have a positive test and it hasn't been confirmed that they're positive, you're obviously, you don't want to follow the, like the Cal OSHA guidance, send them home, ask them to self-monitor, those kinds of things. So if they think they're sick or you think they're sick, you want to get them out of the workplace, and you want to get them self-monitoring and making sure that they're not infecting other people. But if they test positive, now that's different. Again, remember, they have to test positive for this presumption to come into play. So somebody can come to you and say, hey, I'm sick and I've got all the COVID-19 symptoms. I want to go home, and you can let them go home. But if they don't go get a test and test positive, then there's not going to be this workers' comp presumption. To get that presumption, they have to go get the test and they have to test positive. So we got to make sure that we're following that. It's not just that, hey, I think I've got it, so they get a claim form. No, they have to test positive to have a comp claim and for it to be presumptively covered by comp. Will our business be affected if we adopt the position noted in the insurance carrier instruction on reporting claims? For example, will we be subject to any fines or penalties for not providing a claim form within 24 hours? I think you're going to be subject to the same kinds of things that would apply if you don't provide a timely claim form in any regard. I don't know that there's anything special about this that's going to have enhanced penalties for not giving them a claim form for this. It's a comp situation. You're going to have to give the claim form, and if you don't give it, you're going to have to deal with the ramifications of not giving it. So you want to make sure that you give them the claim form. Now, again, the DIR has said they're going to put out information on this, and maybe there will be some new information in whatever they decide to put out when they decide to put it out. But again, I checked about 11 o'clock this morning or 10:30, and there was still nothing that they had put out. So once they do that, if they do that, maybe there'll be some clarity on that. But we're going to have to wait and see, I think, before we know for sure. So we're going to have to, sort of wait and see. I've got some questions and answers questions in the Q&A system. And so I'll read through these and answer them as best I can as I go through. The first one is, do you anticipate a legal challenge to adopt and enforce rules and guidelines to administer a complete system of workers' comp? One example is MPN, the right to exercise pre-designated physician, and right to change treating physicians. Again, I don't know if someone's going to step up and try and challenge us in court. Like I said, it was successfully challenged in Illinois on their state presumption of coverage. I don't know if someone's going to step up and try that here in California. We're just going to have to wait and see. Next question: what if the employee has used the emergency pay and has returned to work, do we still need to provide them with a WC-1 form? I think if they went out and got a positive test after March 19, which is the beginning date, right? If they had a positive test after March 19, I think you've got to give them a claim form. Even if they've gone out, they've used up their 80 hours of sick leave, for as this question is kind of asking, they've used up their 80 hours of sick leave and they've returned to work. If they tested positive, then I think you have to give them a claim form. If somebody has not tested positive, again, it doesn't apply. They must have tested positive. But remember, we talked about that one situation where in terms of the TDI is if they, the temporary disability payments, I mean, if they tested positive prior to May 6th, they have 15 days in which to go and get certification that they were in fact temporarily disabled due to this. And so if they come back with a positive test, then I think they've got a rebuttable presumption that they got it at work. So I think you're going to have to do that, even though it happened back at the end of March, for example. I think you're going to have to go back and do that. Next one, will this be considered a separate XMOD? I don't know the answer to that. That's one of the things you would suspect that the state would put out in whatever guidelines they're going to put out. My thought would be that it won't be a separate XMOD. I think that would be too, ambitious in thinking that they might try and say that this is something separate and it's not going to affect your regular XMOD. I think this is going to be lumped in there. I could be wrong on that. I don't know that. I've got nothing that tells me that's the case. That's just my guess. So yeah, certainly don't quote me on that. We'll see what they ultimately do when they put out some guidance. But my thought is that it's not going to be a separate XMOD. I could be wrong on that. Next question, if we do send them to get tested, do you know the turnaround time for the results of those tests? I don't know, but I do know that different tests have different turnaround times. They're working on tests continually, and I know that there are tests that can get results in as few as a couple of days. I know certain of the tests that people use take much longer than that. I've read news reports about various labs and whatnot trying to come up with tests that are almost instantaneous. So I think it really depends on what type of test that's being used and how long that particular test takes to get a response. So I don't have a blanket answer to that. I don't know. What if they're quarantined because of a family member who is positive? They would be provided a form. Would they be provided a form? So if somebody is quarantined because they've got a family member who is in fact positive, okay, they would not get a form, again, because they have to test positive themselves. So if they test positive, so if you've got employee A, who lives with their family member B, and B is positive, A does not get this presumption. They do not get a workers' comp coverage unless A tests positive for coronavirus. So they have to actually test positive themselves. They can't just be, it's not a claim comp form if they are self-quarantining because they've got a family member who is positive. Now that means they're going to get the sick leave entitlement and all that other stuff, right? They're going to be able to get that, but it doesn't mean it's going to be a comp injury. So it's just a comp claim if they are in fact positive. Next question. If we had an employee test positive and have the official test results, they've already isolated, quarantined, and been released back to work, do we give them a comp claim form now? Again, I think that it goes back to that question of did they acquire it after March 19? And if so, I think you've got to give them a claim form. If they tested positive after March 19, I think that they are entitled to a claim form. And then, here's the nice thing about this though, is that if they've isolated and quarantined and they're released back to work, the amount of time that they're able to get temporary disability. And we know that they have to have used all of their paid sick leave prior to getting temporary disability payments. So hopefully they would have used their sick leave and returned to work and not get any temporary disability. So really, I think you might, if that's the case, they went out for a couple of weeks, they came back to work, and they're ready to return back to work, they're probably going to be fairly minimal, expenses in that. So, hopefully not much in terms of temporary disability. Could it be, the cost of the doctor's visits or something like that? But you would think that that's going to be some pretty minimal stuff. So hopefully. Next one, can require documentation of a positive before we provide a claim form? That's a good question. I think that's something we're going to have to wait and see from the doctor or from the state when they put out some clarification. Now, we know for a fact that to create this presumption that it's a workers' comp covered situation, they have to test positive. So this question is a little different. At least I'm reading this question a little bit different. It is that, can somebody come to you and say, hey, I think I have COVID-19. Do we have to give them that claim form at that point, or can we wait until they test positive? My gut instinct is that we can wait until they test positive, but I don't know that for a fact. I think we're going to have to wait and see if the state clarifies that. But we do know that they're not entitled to a presumption of comp coverage unless and until they test positive. So I have to believe that we can wait until they test positive before we give them the claim form, but I don't know that for a fact. So please don't quote me on that, because I don't know that for a fact. I haven't seen anything from the state to clarify that. Scroll down. Is there a special claim form? No, I'm not aware of any special claim form. I think it's the same claim form that you've got. Employers will also experience increased OSHA. My question window just jumped on me, so hold on a second. I'm trying to get back to that question I was just reading. Okay, for some reason I'm not able to. Okay, gosh darn it, my question window is acting up on me. Let me do this. Let's see. Employers will also experience increased OSHA recordable incident rates based on OSHA recording criteria for COVID-19 cases. Are you aware if this will place an employer on a compliance hit list? I don't know what that might do. Yeah, I mean, certainly you're going to get more claims, obviously. Is this going to put you on some sort of higher hit list? I think that that's going to be hard for them to do. If they were to do that, I just think it's going to be something that would be difficult for them to do. But I don't know for sure the answer to that. I don't know if they've got enough employees to start doing stuff like that, but we'll see. Some of the farm labor employees cross the border from Mexico every day. How will this affect rebutting the claim? I think that this can help in terms of saying that there might be other options where they got the virus. Is it going to be enough to say, hey, they cross the border every day? No, I don't think that's going to be enough. We're going to have to wait and see if they clarify what is sufficient to rebut this presumption. The governor said it's going to be strict criteria to rebut it, but we don't know what that means yet. They haven't published anything that tells us what that means. So we're going to have to wait and see if they clarify that for us. But that's certainly something that you would raise is, hey, they're crossing into Mexico every day, and so there's a chance they got it there. So that's certainly something you would want to raise. Next one. So we give them the form at this point, since the above question was already answered, and they've applied for disability already. They're going to want to know what benefits they get from workers' comp. What other benefits would there be at this point? Really, it's whatever benefits that they would normally get. They would get, the their doctor's visits. They would get their temporary disability if they've utilized all of their paid sick leave and they're still not able to return to work. So it's whatever, it's the full scope of comp benefits that they can get under this. But again, hopefully, most people that get this recover fairly quickly and go back to work fairly quickly. That's, I think, why they picked the 2 weeks, both on the state and federal level for the paid sick leave. And so hopefully if they're only out a couple of weeks, they've used their paid sick leave, so they're not going to get temporary disability payments. So you're looking at some doctor's visits, hopefully, and hopefully it would be pretty minimal at this time. But if an employee says, what benefits am I entitled to get? Well, you're entitled to get any of the benefits that are available under workers' comp. So that's, unfortunately, it's that broad. Monterey County said, I cannot mandate they get tests. Can we force them to go? No, absolutely not. You cannot force somebody to go get a medical exam. Absolutely not. You cannot. What you can do is if they're sick, you can prevent them from coming to work. And if you fall under the state's supplemental paid sick leave, if you're over 500 employees, and one of the criteria under there is clearly that if you are preventing your person from coming to work, they're entitled to that 80 hours of paid sick leave, right? They're entitled to get that, but you can't force them to go get the test. Now, it seems to me that people are going to want to go get the test to test positive, A, because it's easier for them to justify the paid sick leave, and B, it gets them workers' comp coverage if they get it, but you can't force them to do so. When an employee is quarantined multiple times due to a coworker testing positive, but they're not testing positive, can an applicant attorney assert that a quarantined employee has a valid argument for lost time workers' comp benefits? Not the way I read this order. The order is really, really clear that you must, in fact, test positive. So you have to test positive to get benefits. So I don't think that they're going to be able to say, hey, this person lost work because of, a coworker was positive, so this person had to be quarantined. I don't think they're going to be able to argue that this is a good case for comp benefits. I think it's really clear here that they must, in fact, test positive to themselves to get benefits. Next one, they still get a claim form, even if we know they're quarantined because of a family member. Again, if they don't, I don't think they get a claim form until they test positive themselves. So if they're quarantined because their spouse or their child or somebody that lives in their house has COVID-19, that's not enough. I think they have to test positive themselves. Next one, we're seeing and hearing ads from applicant attorneys for COVID-19 cases. They're the ambulance chasers. Can we expect life-term claims like asbestos? I don't think you're going to get that, because this COVID-19 isn't something like asbestos that's going to, that's super serious. The vast majority of people recover from this. About 1% of people who get COVID-19 actually die from it. So it's a really low fatality rate. The vast majority of people that get this don't go to the hospital. I think there's 80% of people who get this don't even have to go to the hospital. They just don't feel very good. And so I don't think you're going to see something like, asbestos claims. I don't see that. It's generally speaking, for most people, and I know there's all this talk about, should you compare it to the flu or not? But for most people, it really kind of is like getting the flu. You're sick for, a few days or, a week or whatever, and then you go back to work and you're fine. That's truly the case for the vast majority of people. A very small percentage of people end up in the hospital, and a tiny percentage of people will die from this. So I don't think we're going to see something like that. I could be wrong. Again, I am not a comp specialist. I don't do comp cases, so I could be wrong on that. So don't quote me on that, but I would be surprised. Next one, if someone says they think they have it and want to continue to get paid until they get tested, is the employer obligated to pay the employee? Or can the employer ask them to use sick pay hours, if any? I think if somebody says they think they have it, I think you can tell them that they can't work. If you tell them they can't work, then I think you've got to pay them. So they would be getting their paid sick leave, and so they would get their paid sick leave, and then you know, they need to either meet the criteria that the CDC and Cal OSHA puts out about when somebody can continue to work, and they have put out some pretty good info on you know, workers in agriculture and other essential industries, where they make it easier for people to continue to work, provided they're wearing gloves and masks and things like that. And you know, I forget, it changes, and so I'm not sure what they're currently saying, but you know, if it's been 7 days since they, you know, last had a fever, they're able to go back to work. Something like that. So I don't think that you're looking at long-term stuff for the most part. And I think that, you know, but again, if you're telling them, if they come to you and say, hey, I think I've got it, and you say you need to stay home, you need to pay them their sick leave. And then hopefully it gets resolved before the 80 hours of sick leave is expired. Let's scroll down here a little bit more. We have a field worker exhibit to show signs of symptoms of COVID-19. As long, again, there's not really a question here, it's just a statement, but if they exhibit signs, don't let them come to work. Tell them to go home and pay them their sick leave. But I think for purposes of the conversation we're having today, is whether it's a comp injury or not, until they get tested positive, it's not a comp injury, and it's not a presumption of, you know, course and scope of work. In the event of an employee death, if there are no dependents established, the death defendants units shall waive any right of recovery. Do we anticipate any change to this? I don't think so. Again, we're going to wait and see what the Department of Industrial Relations puts out in terms of guidance on this, but I don't think so. If there's no dependents and there's a death, I just think there's not going to be a death payment. I think that's the way that it's written up, and I think it'll probably stay that way. But that's, you know, again, we have to wait and see if they change that when they put out some guidelines. We'll see, but I don't anticipate a change to that. So here's the follow-up question to the one above. Can we send them home if they show signs? Tell them to see the doctor, get tested. Don't provide a claim form until they are tested. Yeah, I think, you know, if somebody has symptoms, you got to send them home. Follow the guidelines that the CDC certainly has put out guidelines, and I know, you know, like if you're in Monterey County, I know that Monterey County has put out guidelines on what to do. Certain counties have, certain counties haven't. But basically, you're going to send them home and tell them to self-monitor. And you know, one of the follow-up questions is, can we force them to go to the doctor? What if they won't go to the doctor? You know, if they won't go to the doctor, then they need to stay home until they have gone, you know, whatever the current standard is. And again, it changes. You have to check on an ongoing basis, but, you know, 7 days since they've had symptoms, kind of thing. You know, then if they you know, don't go to the doctor, that we can't force them to go get tested. And so, you know, you just have to say that you got to make sure you've stayed home long enough so that you're no longer contagious. So that's what we do. So yeah, this question keeps coming in bits and pieces. So yeah, if you have them get a doctor's letter to return to work. You know, if they've tested positive and it's going to be a comp claim, you know, they've got to get recertification, and there's got to be a follow-up test. And so they're going to have to do that if they want to have comp coverage. But if you have people who leave and don't want to go to the doctor, again, we can't make them go to the doctor. They would be off on leave, and they'd use up their paid sick leave. And, you know, if they're still sick and they can't come back to work, they can't come back to work. So, all right. I think that is, as of now, the end of the questions that I have. So if we have anything else, if anybody wants to ask, I'm willing to answer a few more questions. If not, I'm happy to stop here, and I'll let you all go on about your day.
Pat, I had one more question.
Yeah.
This is Angelina over in the chat function.
Yeah.
I think you answered the other ones, but I'm not quite sure this one. was answered or asked, excuse me. So the employee has to get a positive test from their own physician, or does the employer doesn't have to go to like the occupational health clinic? So they were asking about who's doctor.
Yeah, it would be whatever your setup is in terms of any comp injury. You know, if they've got a pre-designated doctor, they can go to their doctor. If they don't have one, then they've got to go to yours. So it's however it'd be the doctor that, you know, just like you do on any other comp claim. So, you know, again, if you've got somebody designated, they've got somebody designated, and but remember, it's got to be a physician surgeon license by the state of California. So if their pre-designated healthcare provider is a chiropractor, then they can't go there. They've got to go to somebody who's licensed by the state as a physician and surgeon. So you know, if they don't have one of those, then you're going to use one of yours.
Great, thanks.
Mm-hmm.
That was the only question asked over on the other side that you didn't answer. So
okay, looks like we might have had a couple more write-ins here. Oh, that's just a thank you. What if the employee does not have sick pay hours? The employer does not have over 500 employees. When the employee says they think they might have COVID-19. So if you're under 500 and you're covered by the federal statute, and the employee thinks they might have it, but they don't have any sick pay hours, if they've already used up all their sick pay hours, then they can go home. You send them home and they don't get paid. They're not going to get paid. So if they want to get paid, if they want to get some sort of, you know, payment, they're going to have to go to the doctor and get a test. The test's positive, and then they'll be entitled to get temporary disability payments. But if they don't test positive, then they're not going to get temporary disability under the comp system. But if they think they've got it, you can't let them work. And if they don't have paid sick, you know, if they've used all their sick leave, then they're unfortunately out of sick leave. All right. Okay, I think that's it.
great, thank you so much, Pat, and thanks everyone. We will have the recording available along with Pat's permission, the PowerPoint presentation as well for those of you asking on our website. We'll send a note when everything is ready. Thank you all.
Thank you. Have a good day.
Thanks. Bye.